Simon here. Welcome to the standalone Brussels 4 Key Facts tutorial. We say it's standalone because it doesn't particularly fit into any one single place in the chronology of the remainder of the tutorial course. It is something that you would want to listen to perhaps at the beginning, in the middle, towards the end, at the end, and from time to time afterwards, because it is, as it sounds, simply the key facts. When you hear it for the first time, you'll not necessarily understand everything there is to know about each of the key facts. As time goes by, you will become comfortable and familiar with all of them. Your purpose in working through the lessons in the Willwriters Association Brussels 4 training is to be able to navigate and comprehend all of the facts that make up the totality of this new situation as it applies to people from the British Isles, who we also call English-speaking people. What follows in this lesson then are simply those key facts without any surrounding explanation. The first time you hear them, they probably will sound complex, maybe even lengthy and confusing, but what we recommend is that you work through the course and from time to time listen again to this short tape to identify how many of those key facts you are completely now at home with. There will come a time when you're comfortable with all of the key facts. That will not mean you know everything there is to know about Brussels 4, because your marketing journey is going to take you down many roads which we must prepare you to travel. Not the least that each of the 25 countries affected by Brussels 4 has its own unique footprint, and so things that are important to know about Spain are unimportant or completely different for France or Italy. But nonetheless, all of the countries have their common characteristics that you must be warned about to make your will writing across all of the EU safe, even though that will writing is most likely to be conducted with clients who are living up the road from you back in the British Isles. Here then are the key facts. The Brussels 4 Directive became law in 2012, but only becomes obligatory upon 25 of the 28 EU countries from the 17th of August 2015. Every country in the EU is signed up to Brussels 4 other than Great Britain, Ireland and Denmark. That means that the directive applies in those countries that are signed up to citizens from those countries that are also signed up in both directions. Also, the directive applies in those countries that are signed up to citizens from those countries who are not signed up, as well as to other countries in the world. So a person from Canada, which is not in the EU, or America, just as much as a person from Ireland or England that are in the EU, can write a Brussels 4 will in France, and it will function whether they have elected to write a Brussels law will under French law, or have chosen to write a will of their homeland. We spoke about Canada, America, Ireland, England, covering their assets in France. Both will work following the introduction of Brussels 4 across the EU. What cannot happen within the EU is that a person from, say, Spain, living in the United Kingdom cannot write a Brussels 4 will in England, meaning a will written by way of the English system, which does what a Spanish will does. Though in reverse, an Englishman can write a will in Spain under the Spanish system, yet doing what an English will would do: freedom of disposition. The EU directive introduces two simple options as regards wills and probate for people who live in a country other than that of their nationality. Those two options are to write a homeland will, which must cover their entire worldwide estate, is option 1. to write a will of the country where they are currently living, called habitually domiciled, which will also cover their worldwide estate, is the second option. For the people of the British Isles who are not signed up to Brussels 4, there is a higher level of confusion and misunderstanding than exists in other countries. As far as people from the British Isles are concerned, if they do not live habitually in a property that they own in another EU country outside of the British Isles, then they are not able to write a Brussels 4 will. When the second option is taken up, then a special Brussels 4 will enables someone from the British Isles to write a will under the system of the country where they now habitually live. We use Spain as our example in these tutorials, though written in the tradition of the country where they come from. The British Isles being the Channel Isles, the Isle of Man, the Republic of Ireland, England, Scotland, Wales. Option 2 means that, for example, a Frenchman living in Spain would not have to write a Spanish will under the Spanish system, leaving 2/3 of his property to his children, but could write a Spanish will under the Spanish system under the style of a French will, which is more or less the same but varies in the proportion that must be given to children. A person from the British Isles who lives in one of the 25 signed up EU countries can write a pure local will, if you like, pre-Brussels 4, the original style of will for that country, which still exists, of course, because Brussels 4 is a system simply designed for a person from one EU country living in another EU country. It has no impact at all upon the local national legislation laws relating to wills and probate in each of the European countries. No longer can a person from the British Isles write a hybrid will, in Spain called a Spanglish will, which is a local will written under the national Spanish system, but which seeks to deal only with their Spanish property in the style of an English will, meaning not giving property to their children but to each other or a third party. A person from the British Isles who owns property in another country has always been able to, and still can, and in most situations probably should, write a British Isles will covering their assets in other EU countries. There should, however, not be a single last will and testament covering the property in two countries, their homeland and wherever they own property overseas, but two parallel wills, each reflecting the other side by side, each dealing with the assets in those two separate countries. Those then are the key points concerning Brussels 4, some of which you will already be comfortable with and can explain to another person and make sense out of. By the time this tutorial is finished, you will be able to take any single one of those key points and expand upon it and explain it to someone else with confidence and complete authority.